Joining us is our second guest, Father Ranhilio Aquino, the Dean of the Beda Graduate School of Law. Dean Father, or Father Dean, I'm sorry, I'm not exactly sure how to
Father
say it,
na
sir.
lang, Father.
Father Aquino, thank you for joining us and welcome to Storycon po.
Hi,
Hi,
good afternoon.
Father.
Good afternoon. Good afternoon, Ed. Good afternoon, Nami.
Thank you for joining us, Father. Father,
Thank you too. Thank you too.
I read with interest yung inyong post, remanding is wrong on all counts. You have several posts on that and you also posted about yung comments ni Dean Tony Lavinia. But let me ask you this, Father. Kasi ginawa na ng Senado, nag-remand na siya, dalawang order pa ang binigay sa Kongreso. But what can be done at this particular point? Kasi what we're seeing right now is the ball is being tossed around. The Senate tossed the ball to the House tossed the ball back to the Senate by saying that we are deferring action, we're deferring receipt of the remand order. Nagdi-dribble. So what's left for us to do except to watch? Ganun lang ba tayo? And wait for these two chambers to sort things out? Or can something be done by us, by everybody?
Well, this is really disgusting. And it is disgusting because we are supposed to see our legislators behaving like true statesmen. That's not what's happening now. Well, to the credit of the lower house, and I give credit to the lower house, as soon as the order of remand was issued, the lower house issued a resolution ratifying the first three complaint impeachments that were filed.
Yes, sir.
Now,
Yes, Father.
if this dribbling continues and neither house wants to take action, I think aside from the vigilance that our citizens have already started to exercise by massing at streets or pressing their congressmen and their senators to do something, I think interested and qualified parties can bring suit before the Supreme Court and ask the Supreme Court to resolve this matter once and for all.
Oh, okay. So, Father, it's justiciable na po.
Yes, I think very clearly a justiciable question has arisen because there now arises a constitutional question. And the constitutional question is whether the Senate, having received the articles of impeachment, can order a remand and whether remanding is within the powers of the Senate. In fact, the Senate is involved in what is known as a performative contradiction because on the one hand, it orders a remand. On the other hand, it issues summons to the Vice President and orders her to file her answer.
That's the other thing.
Father, yan nga itatanong ko because there are some legal experts who also say, hindi naman natigil yung impeachment with the order remanding. Because of the summons nga that was already officially received by the Office of the Vice President. And in fact, ang sabi ng kampo ngayon ni Vice President Duterte, pinag-aaralan na daw nila how they are going to respond to it. So tuloy-tuloy naman daw yung impeachment process. Parang clarification lang daw yung hinihingi ng Senate. What do you think of those observations, Father?
That's ridiculous, Ami, because if they want clarification, all they do is ask the lower house to issue a resolution of clarification. They don't have to remand the case. You know, when you remand, actually, you send the records of a case back to the court of origin or to the chamber of origin. And that's what's happening now. In fact, remanding is not within the powers of the Senate. The Constitution, Article 11, is very clear. As soon as the articles of impeachment have been constituted, the Senate tries. That word forthwith has frequently been used, and we cannot emphasize it enough. The trial should proceed forthwith. The only power of the Senate is to try. Now, if the defense believes that there is a constitutional infirmity attending the filing of the articles of impeachment, the defense can raise that as a matter of defense, but not the Senate taking the initiative to remand.
Father, dahil wala nga sa Constitution yung remanding, do you think the defense can raise it as an issue dahil you are asking the defense to answer articles of impeachment that have been remanded to the sender. Pwede ba nilang erase yung issue na yon? Bakit kami sasagot dyan,
That's
i-remand
exactly,
nyo?
that's exactly what I mean by a performative contradiction on their part, no? And if
Yes.
the defense will raise the point that they're not going to answer after all the articles have been remanded, that's
Yes.
going to be another delay. You know, Ami, you raised a very important point. You
Yes.
said some people claim that the impeachment proceedings are not delayed as a result of the remand. That's not completely true. Because if the lower house, for example, refuses to concede what the Senate is requesting, the Senate will not move forward. And so the impeachment proceedings will be delayed. So what the Senate did was really inimical to the progress of the impeachment proceedings, of the trial proceedings.
Father, di ba dalawa po yung order ng Senate Impeachment Court when it remanded the articles. The first one is certification that constitutional yung proseso ng pagpasa ng articles of impeachment. I suppose that was already answered by Resolution 2346, yung pinasa ng Kongreso the other night that you mentioned already kanina. But the second order of the Senate is an assurance from the 20th Congress that it is still interested in pursuing the articles of impeachment in the next Congress. I'm wondering lang what happens kung sakaling the 20th Congress says na we are no longer interested. Could they say that? Can the 20th Congress drop the ball on the impeachment articles which were already passed by the 19th Congress? In other words, na-impeaching yung VP eh. Can the 20th Congress say na hindi na lang?
That is exactly the malice and the evil of what Senate has done. Because it opens the door to the possibility that the 20th Congress says, no, we're not interested in pursuing the impeachment that was perfected by the 19th Congress. Now, I say that the move is both illegal and wrong. Why? Because the Vice President has already been impeached. In other words, impeachment is already a perfected act on the part of the 19th Congress. Now, for the 20th Congress to say, no, we're not interested in pursuing the impeachment is tantamount to acquitting her, which the lower house cannot do, and which only the Senate can do at a trial. At a trial.
There's another question related to that, Father, kasi after the senators took their oath, pero before the articles of impeachment were read, which Chief Escudero said is no longer needed, nag-move yung ibang senators to dismiss the case. Pwede ba yun? Kasi there are some legal experts who are saying, kung susundan natin yung sa US, nangyari na rin yun doon. In the case of Trump, na pinayagan naman daw. Pwede ba sa atin yun under our system?
The words of the Constitution are unmistakable in their clarity. So the moment there are articles of impeachment, what follows is the trial. No judge ever moves for the dismissal of a case that is before him. So it is highly improper and unconstitutional for a member of the Senate to move for impeachment. If there is any ground for dismissal, the ground for dismissal should be raised by the defense as a matter of defense and should not emanate from the Senate or any member thereof.
Father, yung basis po ni Senator Bato for moving for initially the dismissal and later on the remand of the articles of impeachment are particularly similar to the petition filed by VP Sara in February this year with the Supreme Court. Yung violation daw ng one-year bar for the initiation of impeachment proceedings in the lower chamber. I also noticed kasi that you also wrote about the case of Gutierrez versus the House of Representatives in 2011, which relates to the one-year bar. Can you run us through that as non-lawyers as to how to interpret itong one-year bar? Kasi obviously dinelay ng Congress yung tatlong impeachment complaints at pinasa yung fourth.
Yes. Gutierrez versus House of Representatives had to do with Merceditas Gutierrez, who at the time was ombudsman.
Opo.
And she complained that since there was a plurality of impeachment complaints, the sheer number of impeachment complaints violated the bar, the constitutional bar, that not more than one impeachment complaint can be filed against the same official within 1 year. Now, first of all, what's the background of this constitutional prohibition? You know, impeachment is an act of accountability against the highest officials of the land. Now, if frivolous impeachment complaints are filed ceaselessly, the elective official will be doing nothing except answering impeachment complaints.
Opo.
That's the reason for the 1 year bar. However, in Gutierrez versus House of Representatives, Justice, I should say, Justice Conchita Carpio Morales, who was the ponente of that decision, had a very useful analogy. She said, what the Constitution forbids is several candles being lit within 1 year. However, if you have different matchsticks, no matter how many they may be, lighting a single candle, there is no violation of the Constitution. So you may have several complaints. If they relate to the same impeachable act or sets of acts, the Constitution is not violated. But here's the point, that you see, you say that the case was brought by Sara, the Vice President, to the Supreme Court.
Opo, in February.
That's a good point you make. And the fact that the Supreme Court did not issue a writ of injunction, did not stop Congress from proceeding, is what we call a pregnant negative. It's a refusal to act that is legally pregnant, which means that the Supreme Court did not find any right, any clear right that was in danger of being violated.
But that's the reasoning now being used by the senator judges.
Yeah.
Pero Father,
Yeah.
you think kapag ganyan, you think in this case the Supreme Court might actually intervene in the impeachment process dahil Senate yun, they're making their own rules on a constitutional duty na naka-ano lang on the Senate.
Yes, it is true that Article 11 says that the Senate has the exclusive prerogative to try.
Yes.
However, under the definition of judicial power that you find in Article 8, Section 1 of the Constitution, judicial power includes the duty to determine whether grave abuse of discretion has been committed by any branch, agency, or instrumentality of government.
Yes.
So, no matter, for example, that the House of Representatives Electoral Tribunal and the Senate Electoral Tribunal are constituted by the Constitution as sole judge of election contests in respect to the members of their chambers, that does not prevent the Supreme Court from exercising its broadened certiorari powers under the 1987 Constitution.
Father, I have one more question, Father, if you don't mind. I don't know if you've seen the video, pero may umiikot na video magmula kahapon kasi si VP Sara is in Indonesia. Indonesia ba o Malaysia?
Kuala Lumpur, Malaysia.
Kuala Lumpur, sorry. In Kuala Lumpur.
Malaysia.
At kasama niya si Senator Judge Robin Padilla at si Senator Judge Amy Marcos. In the same gathering in Kuala Lumpur, pinakilala pa ni Robin Padilla, Senator Judge Robin Padilla, si VP Sara as the next President of the Philippines.
Yes, I watched that.
Sumigaw-sigaw sila ng Duterte. I'm wondering, what are the ramifications of this, if at all?
Well, highly improper and evidently a lack of statesmanship on the part of these legislators. They know very well that they already have been convened as a court. It is true that these people concerned, the ones you mentioned, did not take their oaths, but that does not negate the fact that Senate has been convened as an impeachment court. knowing that they will sit down as judges, they are supposed to exhibit that requisite degree of neutrality and impartiality that allows them to pass reliable, trustworthy, and credible judgment. Unfortunately, they failed that test.
But Father, is there any way? Is there anything? Sorry, not any way. Is there anything that ordinary citizens can do about this? Or kasi sabi nga nila, recusal and inhibition, these are voluntary acts, and nobody can be forced to do anything like that.
That's correct. They really cannot be forced to recuse themselves, and they cannot be forced to inhibit. In fact, there is no rule on inhibition of the senators who are sitting in judgment. However, a sense of delicadeza and a sense of propriety should guide their conduct and should urge them to behave in such a way so as to allow the citizens to repose their trust and confidence in the impeachment court. Otherwise, the citizens lose their confidence completely in the impeachment court.
Ami, any more?
Pero Father, walang penalty, no? There is no penalty for that under the law.
At the moment, none. At the moment, none. However, if they continue to act improperly, there may be grounds to proceed against them under any of our existing laws.
Ano kayang law yon, Father?
Well, for example, the law that requires them to act impartially, and the law that forbids them from conferring undue benefits on anybody. These are all under Republic Act 3019, Graft and Corrupt Practices Act. And I think that I think that all of those laws and provisions would be relevant in this case.
Okay. Well, Father, we really appreciate your insights, but I'm afraid we're out of time. But maraming salamat po for joining us this afternoon and a very fruitful discussion with you. Father Ranhilio Aquino, Dean po ng Beda Graduate School of Law. Thank you very much, Father.
Thank you, Ami. Thank you.
Thank you, Father.